some practice questions based on the portions of the rules that we've already covered in our course so far. Let's turn to question 1. The facts tell us an attorney represented a defendant in a civil case. The defendant was being sued after allegedly running a red light and striking the plaintiff's vehicle. The defendant testified at trial that the light was green when the defendant drove through it. The defendant's testimony was consistent with the story that the defendant had told the attorney in the past. However, the attorney was trained in detecting when someone was getting nervous or lying and did not personally believe the defendant's story. There is no other evidence that the defendant was lying, and the defendant's story was consistent with the story of nearby bystanders. The jury found in favor of the plaintiff. Is the attorney subject to discipline? We start our analysis by articulating the rule that's being tested, so we can try to reach a conclusion on our own. Here, the rule being tested states that a lawyer shall not knowingly offer evidence that the lawyer knows is false. If a lawyer, the lawyer's client, or a witness that's been called by the lawyer has offered material evidence and the lawyer comes to know of its falsity, that lawyer shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. Thus, if a lawyer calls someone up to the stand as a witness and that witness offers material evidence or testimony, and the lawyer comes to know that the information is in fact false, the lawyer has to take steps to remedy that. Here, we're told that the lawyer called the client up to the stand and let the client tell his version of the story that occurred. The lawyer didn't personally believe it, but the lawyer doesn't know whether or not it's true or false. The key with this rule is that there is a knowledge requirement. This is why it's helpful to have the rules memorized. Specifically, the rule says if the lawyer, a lawyer's client, or a witness called by the lawyer has offered material evidence and the lawyer comes to know of its falsity, then the lawyer must take those reasonable remedial measures. Here, the lawyer doesn't know if the information provided is false. The lawyer has an idea, but again, can't point to anything that says, yes, this is in fact false. So because of that, the lawyer isn't under any sort of obligation to reveal his or her feelings to the court about what they think of the testimony. To revisit the call to question, it asks, is the attorney subject to discipline? The answer has to be no, because again, the rule requires knowledge, and the lawyer in question doesn't know if the information provided was false. Let's see if any of our answer choices match with what we just said. A says yes, because the attorney called the defendant as a witness, even though the attorney thought the defendant was lying. A is wrong, because calling someone to the stand, not knowing whether or not they're lying, isn't a parameter set by the rule. The rule prohibits the lawyer from standing next to evidence that they know is in fact false. So A misstates the rule and the attorney's obligation. B says yes, because the attorney failed to take reasonable remedial action after he detected the defendant was lying in court. And B's a good trap answer if you don't know the rule. Here, the rule requires knowledge, and the lawyer doesn't have knowledge of a lie. So B is wrong. C says no, because the jury apparently disbelieved the defendant's testimony. Be on the lookout for answer choices like C. It's kind of like a no harm, no foul type of choice. Here, they're essentially saying it doesn't matter whether or not the defendant lied because the defendant didn't win. And that's not the point. If the lawyer had committed a rule violation, it doesn't matter what the jury thought. The lawyer would still have an obligation to act. So C is wrong. D says no because the attorney did not know of its falsity. And this is exactly the type of answer we were looking for because we know the rule requires knowledge. So D is the correct answer. Question 2. The facts state, one of an attorney's regular clients, who was also a longtime personal friend of the attorney's, was traveling to another country to compete in a competitive sport. Prior to leaving the country, the client paid the attorney a retainer of $100,000 so the attorney could pay the client's insurance bills when they became due. The insurance bills ended up totaling only $80,000. The attorney needed to pay off a personal debt of his own in a short period of time and borrowed $10,000 from the client's trust account. The attorney did not ask the client's permission to do so since the client was out of the country. However, the attorney thought that the client would approve. A week later, the attorney settled a large case of his own and deposited $10,000 back into the client's trust account. Further, the attorney paid 8% interest on the $10,000 and deposited the interest in the trust account as well. 8% is higher than the standard interest rate. So in the end, the client benefited from the transaction. When the client returned from his trip, the attorney told the client what he had done, and the client approved of the conduct. Is the attorney subject to discipline? The rule being tested here is about client's property or funds and the management of it. Specifically, the rules tell us that when a client prepays a lawyer for services or otherwise gives the lawyer property, the lawyer must keep it separate from his own. He must not steal it, borrow it, or use it for his own personal advantage. Here, clearly, the lawyer did just that, and that's a problem. It doesn't matter that the lawyer eventually got permission, and it doesn't matter that he paid extra interest on this loan. What matters is that he used his client's money as if it were his own, and he did all of that without permission. That is the issue. So the call of the question asks, is the attorney subject to discipline? We now know that the answer to this question is yes, because lawyers are supposed to keep client property separate from their own, and they're never supposed to use it for their own personal use. So let's take it from the top and evaluate the answer choices provided. A says no, so long as the attorney's conduct did not amount to commingling of funds. And A is wrong because there is a problem with what the lawyer did. The lawyer used the client's money as his own. This is essentially like commingling because the lawyer dipped into the client's account and took the money for his own personal use. B says no because the attorney reasonably believed at the time she withdrew the money that the client would not object given their long-standing personal friendship. And B is problematic because it's basically saying that there's an exception if the lawyer knows the client. And that's not the case. The rule makes it abundantly clear that lawyers are not supposed to be using client funds or client property as their own. So B is wrong. C says no, because the client was fully informed of the attorney's actions and consented to the actions, thereby retroactively ratifying the attorney's conduct. Well, there's no such thing as retroactive modification under the rules here. That is really not a thing. What happened here is the lawyer violated the rule by taking the client funds and using them as his own, and then he later told the client about it. And that is not okay. Again, there is no such thing as retroactive ratification. So C is wrong. Answer choice D says yes, because the attorney used the client's funds for a personal use. And this is exactly right. In fact, it uses the language of the rule, and it's exactly what we've been saying the whole time. So answer choice D is the best answer. 3. The facts state. The following advertisement appeared in an online advertisement in a state in which both attorneys are members of the bar. Attorney Alan Abel, JD, and Attorney Betty Buttons, JD. Attorneys at law. ABCDE Street, State, 99999. Telephone, 999-999-9999. We have never lost a trial. Both attorneys are new and have never tried a case. Are the attorneys subject to discipline? The rule that's being tested by this fact pattern is all about the attorney's ability to advertise. The rule says that a lawyer shall not make false or misleading communications about themselves or their services. A communication is false or misleading if it contains a material misrepresentation of law or fact, or omits a fact necessary to make this statement considered as a whole not materially misleading. Thus, you can have advertisements that violate these rules if what the advertisement says is technically true, but if it doesn't provide all of the information that is necessary for the client or the person reading it to understand what it's saying. So here in our fact pattern, we have an advertisement for two brand new lawyers who are licensed to practice law, who have never had a case, and yet their advertisement says, we've never lost a trial. So while technically they haven't ever lost a trial, they've never had a trial. Therefore, this is a specific instance where omitting a fact is problematic, because if you knew as a potential customer or client that they've never lost a trial because they've never had a trial, that would mean something to you. That would be important information. It would mean a lot more than them simply saying they've never lost. Further, without the fact that they've never had a trial, makes you believe that they're just so good at what they do that they've never lost. And again, we know that's not the case. They've never had a case to take to trial. So this violates the rules. Let's look at our call of the question again. It asks, are the attorneys subject to discipline? The answer to this question is yes, because while this ad is technically true, it's misleading. Answer choice A says no, because both attorneys are permitted to make statements that are truthful and not misleading. So A is a good resuscitation of the rule, but it's not being applied properly. While these statements are truthful, they are misleading, which is what makes A wrong. B says no, because all the statements are true. Well, the statements being true is only half the rule, right? So B misses the rest of it. The statements have to be truthful and not misleading. C says yes, because their advertisement's misleading. Well, this looks good. We know that while the statements are true, this is misleading, and therefore it's problematic. So let's hold on to this answer choice while we evaluate D. D says yes, because the advertisements are not permitted under the rules of professional conduct. Well, D is wrong. We know that lawyers can advertise, they just have to conform to the rules. So that means the best answer to this question is answer choice C.